Hello, I'm Ken Harrell. I'm the managing partner at the Joye Law Firm. I want to start by thanking you. I know that you had a choice when it came to the attorney or the law firm that you hired to represent you on your case. I believe that by picking the Joye Law Firm, you've made a very good choice. The purpose of this video is to provide you with an introduction to your auto accident claim, including some of the situations and issues that you're going to be facing. The following information will apply in the vast majority of the cases that we handle. If there is an exception in your case, we will discuss that exception with you and how it is going to affect your claim. Let's start with something very basic. This form is a Form FR10. Our clients usually call it the green form. If you have been in an accident and you have not already provided this form to your agent, it is crucial that you do so as soon as possible. If you do not turn this form in within 15 days of your accident, it can result in your driver's license being suspended. So please make sure that you get this form to your insurance agent as soon as you can. If you're meeting with us, we will get a copy of the form and make sure that we get it into your file. Now let's talk about some issues that you will be dealing with in regard to your claim for personal injuries due to the automobile accident. Issue number 1, medical care. The most important goal in your case is getting you well. There is no amount of money that will make up for having a permanent injury if there is treatment that will help you avoid having those permanent effects. Assuming you have health insurance, it is our preference that you have your family doctor direct your medical treatment, if at all possible. If that is the case, your family doctor can then make recommendations about whether you should receive chiropractic treatment, physical therapy treatments, or be sent to a specialist. However, there are many people who either do not have a family doctor or their family doctor will not see them in regards to an insurance claim. If that is the case, we can help line up treatment for you with a doctor. If you do not have access to treatment, please discuss that with us immediately. We want to help you get well. It is extremely important that you keep all of your doctor's appointments. One of the biggest problems we face in resolving a case is if there is a gap in your medical treatment. Every insurance company will make an issue of any gap in the treatment. So the bottom line when it comes to your medical care is this: keep your appointments and get well. Now let's talk about your lost wages. First, if you can work, you should work. If your employer has light duty available for you within the restrictions that your doctor has placed on you, you should try to work. You want to try to keep your lost wages as low as you possibly can. Now, one worry that a lot of people bring up with us is, will I lose my job if I'm out of work due to the injuries? Well, obviously, we cannot give you a guarantee as to how your employer is going to deal with this situation. What I can tell you is that if you work for a company with 50 or more employees, you will have some protection under the Family Medical Leave Act. This law states that any company that has 50 or more workers is required to protect your job for up to 12 weeks if you're out of work due to having sustained any sort of significant injury. In our opinion, the best way for you to keep your job is to stay in touch with your employer. If you are given a work excuse or physical restrictions form by your doctor, please get us a copy. We need that for your file. But also make sure you get it to your company as soon as you can. Also understand that for us to obtain lost wages for you, we will have to have a work excuse from a doctor. We are not able to recover those damages unless we have a work excuse. For example, if you stay home from work for a week because you don't feel well, we will not be able to recover those damages for you unless you have medical documentation stating you needed to stay out of work. Keep track of your missed time and your lost wages. It will be much easier to get your employer to fill out the standard form we will provide if you can show them your record of missed time and lost wages. If you are self-employed, document. We will need some documentation in writing, tax returns, contracts, or other documents that show lost or incomplete jobs in order to obtain lost wages for you. The insurance company won't pay lost wages unless we have some documentation to prove what your loss has been. The next big issue I want to talk to you about involves the property damage to your car. And unfortunately, there's some bad news. You will never come out ahead on your property damage claim. Never. The best that you can hope for is to come as close as possible to breaking even. And you will never completely break even because there will be no recovery or payment for the hassle that you're going to go through related to the damage to your car. Here's what you can normally expect to recover. First, a rental car. You will be entitled to a rental car for a reasonable period of time until you can get your car fixed or find a replacement. However, if your car has been totaled out, most insurance companies are allowed to cut off the rental coverage once an offer is made for the loss of your car. So if your car has been totaled, try to get into a replacement vehicle as soon as you possibly can. We also would urge you to make arrangements to get all of your personal belongings out of your car as quickly as you can and to take the tags off. Second, when it comes to property damage, is the cost of repairs. If your car is fixable, you will be entitled to have the cost of repairs covered by the insurance company. Please note that the insurance company is often able to dictate which body shop you are to use for the repairs to your car. Finally, if your car cannot be fixed or is totaled, you will receive what is referred to as the fair market value, or in some cases the book value of the car. If you have questions about what the book value of your car is, you can go to www.nada.com or www.kbb.com, that stands for Kelly's Blue Book, to find out what the book value of your car is. Now let's talk about mitigation, which is just a fancy legal word for lessening your damages. You have an obligation to lessen your property damages as much as you possibly can. If you have full coverage on your car and you don't hear from the liability insurance company within a few days of the accident, our advice is to call your insurance company to get your property damage claim started so you can get your car fixed as soon as possible. Your insurance company will then have the right to get reimbursed by the at-fault driver's insurance company. It's important to be proactive. Otherwise, the other insurance company for the at-fault driver might be able to argue that you didn't meet your legal duty to lessen your damages. We can give you guidance on property damage issues, but you're better off dealing directly with the insurance company on your own on the property damage issue. However, never discuss your personal injuries with the insurance company representative that you are dealing with on property damage issues. If by any chance you've already given a recorded statement to any insurance adjuster, please let us know this. It's very crucial that we get a copy of the recorded statement as soon as we can. Why are you better off dealing directly with the insurance company for your property damage? The biggest reason is we don't want to charge you a fee for your property damage recovery. Handling it on your own will save you money. Your goal should be to settle your property damage claim as quickly as possible, and then let us help you try to make up the difference on your personal injury claim. 99% of the time, your claim will be paid by an insurance company, but there are several different types of insurance that can come into play. First, let's talk about liability insurance for the at-fault driver who caused the accident. This insurance company usually pays your claim. Some companies are easier to deal with than others. If the at-fault driver in your case is insured by Allstate or Progressive, get ready for a fight, because we know from experience that these companies are difficult to deal with. The amount of available liability insurance coverage is going to vary from case to case. In South Carolina, the amount of liability insurance coverage for any one individual's claim can be as little as $25,000. Most drivers will only carry $25,000 in liability insurance coverage for any one claim made against their policy. Liability policies also have a cap on the amount that they will pay out for multiple claims. Minimal limits coverage is also known as 25-50 coverage. That means that $25,000 in coverage is the most that will be paid out to any one person for an injury claim filed against that policy, and $50,000 is the most that will be paid to all injured persons combined if more than one person has been hurt. So if 5 people have been badly hurt by a driver who has 25-50 coverage, the $50,000 in coverage will have to be divided among the 5 people. For accidents occurring in South Carolina on or after January 1, 2012, the liability insurance company is now required to tell us how much insurance coverage was in effect. Before that date, this information was typically not divulged until a lawsuit was filed. This was a helpful change in our law, as our goal is to try to avoid a lawsuit if possible, because if we have to file a lawsuit, which we have to do in perhaps 20% of the cases that we handle, we know that it's going to take an awfully long time before your case is resolved, because it can take 2 years or more to get a trial date set. Also understand that the amount of coverage that an at-fault driver has does not mean that is the amount that is going to get paid to you on your case. If your case is worth $5,000, you will be paid $5,000, no matter how much coverage is in effect on the at-fault vehicle. In some cases, we will be dealing with your insurance, even though you were not at fault. Assume that the driver who caused your accident was uninsured. Insurance Research Council statistics show that 11% of South Carolina drivers are uninsured. If you've been hurt by one of those drivers, we will have to go to your insurance company to have them pay the claim using your uninsured motorist coverage. Every driver who buys liability coverage in South Carolina automatically is provided uninsured motorist coverage in the same amount. An issue that can come into play when we're dealing with a situation like that is stacking. And I don't want to go into a long legal explanation of that, but just know that in certain circumstances, if we're dealing with your personal uninsured or underinsured motorist coverage, we may be able to stack your coverages to increase your recovery if you had more than one household vehicle. Here's another situation. Let's say that your case is worth more than the amount of liability coverage that the at-fault driver had in effect. For example, assume your case is worth $50,000, but there's only $25,000 of coverage on the at-fault vehicle. Hopefully, you have underinsured motorist coverage. If you do, we can then go to your company and use that coverage to try to make up the difference for a full damages recovery. If you don't have underinsured motorist coverage, call your agent today and ask how you can get that coverage. It won't help you with this claim, but it's dirt cheap coverage which will help protect your family and you in the future if there's another accident. You also may have what is called medical payments or personal injury protection coverage, which is almost a source of double coverage for certain types of losses that you may have, such as your treatment bills. Sometimes personal injury protection coverage can even cover lost wages up to a certain amount. If you have that type of coverage, and our attorney and case manager will look at your documentation to determine what coverage you have, we will be able to help you collect that money from your insurance company, and we will not charge a fee for any payment based on medical payments or personal injury protection coverage. Finally, if we're dealing with your insurance company, know that your insurance company is not going to be your good neighbor, and if we make a claim against them, they are not on your side and you are not in good hands. They will fight your claim just like the at-fault driver's insurance company will. That's what insurance companies do. So just because it's your insurance company, that's not going to make it any easier for us to get you a full and fair recovery. The question that we get asked most by our personal injury clients is this: what's my case worth? How much money will I get? The only honest answer we can give you is, we don't know, and that's especially true if your accident has recently occurred. It's way too early to tell. There are several factors that will determine what the value of your case is, and I want to review some of them with you. Number one, how badly have you been injured? If you have a case where, God forbid, you have a broken leg and you have to have surgery to repair your injury, or you have a herniated disc in your back that requires surgery, or you have a torn rotator cuff in your shoulder, that case is going to be worth much more than if you have a case where you have some muscle strain, which may be very painful, but in the course of a few months, you should completely recover from it. That brings up the element of pain and suffering. What an insurance company is willing to pay for something like pain and suffering or loss of enjoyment of life is going to be much higher when you have more severe injuries. A second factor, are you left with any permanent injuries or any disfigurement? Again, if your accident caused a herniated disc in your back and you have to undergo surgery for it, unfortunately, you're never going to be 100% again. You're never going to be completely back to where you were before the accident occurred. If so, that will be a significant element of damage in your case, and your case will be worth considerably more than if you have an injury that you completely recover from in 6 weeks. A third factor is the amount of your medical bills. How much did your treatment cost? The insurance companies can deny this, but your treatment costs are a key factor they look at in valuing your claim. And many apply some formula to what your medical costs are to determine what they will offer you. A fourth factor, what is the amount of your lost wages? Have you missed any time from work? And if so, how much money have you lost as a result of your being injured in this accident? A fifth factor, will you have any future disability as a result of your accident injuries? If you're not going to be able to go back to the type of work that you've always done, or in some catastrophic injury situations, not going to be able to go back to work at all, that's going to significantly increase the value of your case. A sixth factor, How bad was the crash? What was the damage to the cars? If the damage to your car is a scratch on the bumper, there's a good chance that we may decline representation or possibly offer to see if a lawyer in our referral network will take your case. That's not always the case. If there's little damage to your car, but the car that hit you looks like it just went through a smash-up derby, then we'll be more inclined to take your case because we can still prove the severity of the collision. If you have limited damage to your car, but unfortunately you fractured your wrist, we're going to take that case because that's an objective injury we can point to and say, our client did not have that injury when they got in the car before your insured hit them. There have been many cases where good people have sustained injuries and we've declined representation because of very limited property damage. And people will often ask us, why do you do that? 2 reasons. Number 1, we know that if there's limited property damage, it's going to be very difficult to get the insurance company to make any offer on the case. We could live with that. But the second reason is that juries in South Carolina tend to award very little damages if there's limited property damage. It's purely a business decision. We have to look at the property damage as one factor in determining if it's a case that we're going to take on. The next factor, what did the at-fault driver do wrong? If you were injured due to a drunk driver running a red light, your case will be worth more than if you were injured because some grandmother got distracted and rear-ended you. Because with the drunk driver, we can recover what's called punitive damages. The bottom line is that we cannot judge your case value until your treatment is done. Then we can look at these factors that I've just gone through and many more to try to determine what's the value of your case. Unfortunately, there are many situations where the value of your case for a severe injury may be far more than the amount of coverage for your claim. As soon as we can, we will work to get a settlement offer made by the insurance company. We will then negotiate to get the highest offer we can get, and then we will give you our recommendation of whether you should accept the offer or whether you should let us file a lawsuit. We are here to advise you, but this will always be your decision. It's your case. If we cannot get the case settled and we believe that a lawsuit should be filed, we'll discuss that issue with you. As I said earlier, in our experience, 80% of all automobile accident injury cases settle before a lawsuit is filed. The next question, why hire a lawyer? Why shouldn't I try to settle on my own? If you've been hurt in a car accident, here are several reasons why you will be better off hiring a lawyer. First, the increased recovery that you're likely to get. Like anything else, there are no guarantees, but I can give you statistics. A study by the Insurance Research Council indicates that persons who have been injured in an accident who retain a lawyer to help them recover on average 3 times more than persons who settle their case on their own. So even if you factor in a legal fee, statistically speaking, you will come out ahead by letting a lawyer help you. Second, if necessary, we can help line up treatment for you. Again, the main goal is to get you well. But if you don't have health insurance or your family doctor is refusing to provide treatment for an automobile accident injury, then we can help get treatment coordinated for you with a doctor who will treat you based on a letter of protection. If you need to see a specialist, perhaps your family doctor says, I think you need to see a surgeon. We can give you input based on our years of experience in handling these types of cases about good specialists who can provide the type of treatment that you need. In some cases, we can even get hospitals and doctors to provide your surgical treatment based on a letter of protection. Third, we can work to get your medical treatment bills paid for you once your case is settled. You want to know that once you get your recovery, that you are not going to have to worry about those bills coming up later. If there's limited coverage, we can often get medical providers to take a drastic reduction on their medical bills. We do need your help to make sure that we get all of your bills covered. If you go to see a different doctor than the ones we know about, or you go back to the emergency room to get more treatment, you need to call us right away and let us know this. If you don't tell us this, it will probably be too late if you call us after your case is settled. And I know it will be too late if we have already dispersed the money from your settlement. Please keep us updated about your treatment. Fourth, we can help guide you through the confusing complications that often exist in these cases. Let me give you just a couple of examples. First, health insurance liens. If you have health insurance, or if you have Medicare or Medicaid, use it to cover your accident injuries treatment. Many people tell us, why should I use my health insurance? the accident was somebody else's fault. It doesn't matter. Using your health insurance will help you in two ways. First, it will help you get access to the treatment that you need, and you deserve to get complete and full treatment if you've been injured due to somebody else's fault. Second, it could help increase your monetary recovery. How is that? Let me give you an example. Your health insurance company will usually have the right to get some of its money back once you get a recovery from the liability insurance company. I won't get too legalistic here, but there's a law called ERISA, and if it is an employer-funded plan, we may not be able to reduce the amount that your health insurance company gets back. But in many cases, we can get that amount reduced. So by way of example, if your health insurance company pays $3,000 of your treatment bills, and we end up only paying the health insurance company back $2,000, who gets that $1,000 difference? You do. So again, use your health insurance if you have it available. Another complication is if you were working when your auto accident occurred. If so, we can help you get a recovery both under the workers' compensation system and for the automobile accident by asserting a claim against the at-fault driver. But there are complicated rules and procedures that we have to follow in order to do that. Finally, we can help you deal with your stress. If you sustain severe injuries due to your accident, you have some hard times ahead of you, and unfortunately, we don't have any magic solutions. Unlike a typical work comp situation, there will be no weekly benefits coming in, so you can be under severe financial stress. We are here to listen, and we are here to help you. If there's anything that we can do to try to reduce your stress and financial hardship, we will. The final thing I will cover is how our practice is set up. There will be two people assigned to your case, a lawyer and a case manager. The lawyer will handle all legal issues on your case. The lawyer will negotiate your settlement and will advise you on case value. Our job as your lawyer is basically to be your expert based on our years of experience in handling these types of cases in South Carolina. For most day-to-day issues, the case manager will be your main contact person. Our case managers are well-trained and they love helping people. If you have a question, please call your case manager first. Generally, the case manager is going to be easier to reach than a lawyer, who is often out of the office for trials and hearings. If a legal issue is raised, the case manager will let the lawyer know so the lawyer can get back in touch with you. Second, it's crucial that you keep us updated. When should you call us to give us an update? You should call your case manager after every appointment that you have with a medical doctor to let the case manager know what the doctor said, what additional treatment has been recommended, how you are doing as far as your current physical condition, and when your next appointment is scheduled. Then when do you not need to call us? If you're receiving chiropractic or physical therapy treatment, you don't need to call us after each of those appointments because we know that those treatments tend to be the same each time. But when you are released from your doctor, your chiropractor, or from the physical therapy treatments, call the case manager immediately so we can get updated records and bills to get your settlement package out as soon as we can. Thank you for watching this DVD. I hope it's been helpful. If you have any questions, please let us know. People will often say, "Well, I hate to bother you." Your call is not a bother. This is our job, so put us to work if you have a question. We look forward to working with you to get this unfortunate situation resolved for you as soon as possible. Thank you.